seated, please. Court calls Blackstone Holdings versus Primexx Energy Opportunity Fund. Who's present for the appellate?
David Cole for the appellate, Your Honor.
And for the appellee?
Ryan for it.
All right, 20 minutes per side, preserving some time.
5 minutes, please.
Okay. Proceed.
Afternoon. May it please the court. I'm the warm-up act to a pretty significant question of corporate governance in the next appeal. This is obviously a more niche item. And so I want to speak to one aspect of it. I think it's the key aspect of this appeal.
Don't downplay it. There's some of us that love personal jurisdiction cases.
In that case, I'll savor every syllable. It's a way to think of personal jurisdiction law, Justice Brister. It's like a checkbox, and you want to just make sure you have all the issues covered.
Very nice.
But now I've logged that one. So the issue I wanted to speak to is this question of waiver, because there's the minimum context issues that honestly I think are well set out in the briefing in both appeals, and we can spend our time in other issues. But the question here is an issue of construction of a very basic rule. It's been around a long time. There are surprisingly few cases. Rule 120A tells us you can make a special appearance for an entire proceeding. And our Supreme Court, this Jaster case that we cite, did an exhaustive review of cases that use the word action, proceeding, cause of action, claim, categorize them in any number of different contexts. And this is not in the briefing, this is not in the cases, but my suggestion, having looked back at it fresh for this argument, is that an action, a proceeding, has two properties. They recur in those cases, and they explain the cases that were cited in the briefing on this issue. It has a separate cause number, it's a separate procedural entity, and it is capable in its own right of producing a final judgment. Though it's not perfect, but I think those factors make some sense out of those cases, and they make sense out of the precedent that's been cited to this court. For example, there are, I think, 3 cases in Texas that have dealt with this rule. They are readily reconciled using that approach to things. We have one, this Sejas case, where someone moved to dismiss earlier lawsuit ends, new lawsuit is filed, they raise a special appearance. That's a separate action because it's a separate cause number, and the final judgment in that case would be distinct from whatever happened in the first case. Waterman Steamship, which we believe to be the most analogous case, same thing. There's a separate cause, there's a later lawsuit, and there is a motion filed. This Massachusetts Bay case, which is the contrary case, deals with the same case. It was an action, it was consolidated into a later MDL, it became the same case. It simply had a way station along the way, easy enough. There is a distinct definition of what an action is, and this break in all these different lawsuits over time means it wasn't the same action, which means we now no longer are really looking at Rule 120A, we're looking at rules of estoppel. There are a couple of different estoppel doctrines that my opponents cite. That's how you can tie 2 distinct actions together. It has nothing to do with the rule. It's just what estoppel doctrines do. And
what is the best Texas Supreme Court guidance for us on this judicial estoppel?
So there's not really a Texas Supreme Court case. It's scattered all over the place in the courts of appeals. And there's, unfortunately, an unsettled question as to whether it has to be under oath in the first action. The precedent on that is scattered in the courts of appeals. I don't think the Supreme Court has resolved that decisively. So I don't think we have the good fortune to have an on-point Supreme Court case, nor can you really have one. These judicial estoppel cases tend to involve all sorts of case-specific issues. Consistency, though, is the question. And again, there's not really, I don't have a case about this particular fact pattern, but I do know our position's consistent. I mean, the position we took in the initial action was about them. We said, you are bound by this agreement. It requires a certain way to proceed in the lawsuit. And that doesn't have anything to do with us being bound by it or being a party to it or any of the other things that they claim. It's consistent with our position here that you don't have, you have the claim you have, and we don't have any business being part of it.
You did ask the court for some kind of affirmative relief. Get
Right.
rid of the case and let us
That's
go
true.
in federal court, right?
And not in that action, of course, right? That's where we go back to the rule. That request would have no effect
Well,
on later
only because
action.
you can't transfer.
Yeah.
If the transfer, if it had been a form selection to state courts in El Paso, you would have transferred it, but you can't transfer from the state court to the federal court. Why should that be a different
Well, because in terms of what the rule applies to, it's a different action. It's a different cause number, different procedural device, different judgment. In terms of estoppel, request to transfer is not an estoppeling thing. It doesn't create an estoppel. Estoppel has to be a statement of fact, a statement of position. A request for relief is, at best, some kind of a legal argument, but that doesn't create a judicial estoppel. It doesn't create an admission in that action.
So I understand that argument, but when you agree to the thing that puzzled me about this, I may have missed it, but when you agree that exclusive jurisdiction will be in the federal courts in Dallas, Texas, why have you not waived objection to being hailed into court in Texas?
Well, the exclusive jurisdiction, if there is jurisdiction, right? I mean, people have forum selection clauses all the time to dispute personal jurisdiction and other issues.
Yeah, and my understanding, are you saying my understanding is wrong? If you agree to exclusive jurisdiction in Missouri, you can still come back and say, oh, no, I never agreed to jurisdiction in Missouri?
I've agreed that of all the places where there could be jurisdiction, it'll be Missouri, but I don't agree that you can bring any crazy thing in Missouri that any connection to that case.
So-
I mean, different wording could achieve different things, but this clause is just of the places it can be filed, this is the place. It's not a mandatory consent sort of thing, and that's not the argument they're making either against our
Let me make
position.
sure I understand what you're saying, though. Let's assume that we are on appeal from the very first action filed. Had your client filed that same motion to dismiss, and then, let's say it was denied, and then you file a special appearance, are you saying that first filing would not have waived the special appearance?
It could have. I haven't run that all the way through, but the argument would be stronger than in this case, because you'd be in the same action, and then
Right.
the order of pleading rule would kick in, which of course has nothing to do with being in separate actions.
So to follow your argument, you're saying that's the 120A argument, because we're not in the same
Right.
proceeding. Then you have to look at it from an estoppel perspective.
That's right. You look at the judicial estoppel thing, and there the question, judicial estoppel and Rule 120A come from different places, right? Judicial estoppel is this much farther reaching thing that you can't trick somebody into doing something here and then move positions later on. It stops shifting of positions. And
Does it
that's-
matter that you are, basically, I know it's the fourth proceeding technically.
Yeah, there's not a lot of.
But you've got the same basic parties, same basic facts, and same basic claims, right?
It's similar as they were in the other two cases that have gone our way as close there's been. I mean,
Does that matter?
Well, as to the action part of it, it could. I mean, if you have the same parties, at some point, you start looking a lot like the same action, except for the problem of the cause number and the judgment that I identified earlier. But those are warning signs that you're heading into something that's probably the same action. In terms of estoppel, I don't think so. I mean, estoppel asks, is it the same person? We have to be the same people. But it isn't necessarily the same person on the other side of it. The question there is, has some court in some way changed position?
Well, is there any risk that we would be creating kind of opportunities for procedural gamesmanship
Yeah.
if we go down this road?
I mean, there have been 3 cases on this aspect of Rule 120A in the history of Rule 120A. That rule's been on the books as long as there's been special appearances in Texas, so it just doesn't come up very much. And if the problem here is mischief, I think it's the other way, because the rule says action. It doesn't say closely related action or any number of other things. And so I think the risk of problems is greater if action actually means something other than what I suggest it means. So the risk is low either way. This is a little bit of a one-off, but given, you know, where the case law has been compared to where it could go, I would suggest that we stick with action and try to keep that consistent with what the cases have generally applied it to mean.
So what do you do? Somebody files identical claims against you, one in El Paso and one in Beaumont. You decide, I don't want to be in Beaumont, I want to be in El Paso. So you file a special appearance in Beaumont, and you go ahead and litigate in El Paso. We can't let people just pick and choose.
Goodness gracious. It's, Yeah, so I'd be against the same people, I suppose. There'd be, I mean, the cases would likely be consolidated at some point, and somebody's gonna request a transfer. But the chance you have two cases just going in isolation like
You're
that would be
dodging,
hard to
you're
believe.
dodging my hypothetical.
Well,
I can tighten it up
I'm,
if
que-
you want.
I'm questioning whether that would, I mean, I get it, that could but that didn't happen in these other cases.
Right, well,
One
but
case dies or
You're
they
s-
get MDL.
But you're saying it's an entirely different case. Yes, it's exactly the same parties, same claims, same everything, but it's an entirely different action. So that one, we appeared in because we wanted to get a transfer venue, but when it was refiled again, we didn't appear in, and so we are okay to file a special appearance. That looks like picking and choosing.
Yeah, so that's the fact pattern of the two cases I led off with, is there were two actions, one ended, a new action began,
My
somebody raised a special
recollection is, though,
appearance.
there's cases going both way on that.
Oh.
I mean, one of the minimum contacts is, do you litigate cases in Texas?
Right, that's true. You can consent, obviously, to jurisdiction in Texas, but that's a different question here. The Rule 128
I don't
question
see
is
why
it an
that's a
action?
different question.
Is it
You
that-
showed
yeah.
up and litigated exactly this case. Didn't litigate it far, I'll concede,
Yeah.
but you showed up and appeared and filed, file an answer, or you have to file an answer to file a motion
We
to
filed a lot
transfer
of
venue.
things. The record shows a motion, we filed a special appearance, we filed a motion to transfer, we filed special exceptions, we had a lot of quarrels with their pleading.
So you filed a special appearance in the first action?
Yes, it didn't get heard for whatever reason, but it was resolved, that there was one on file.
It has to be heard first, doesn't it?
Yeah, right, so it's just neither here nor there. It's in the record, but it's not relevant to your hypothetical. But I just wanted to show off that I knew it was there.
Okay, all right, that sure looks like,
Look, there's two different things going on here. There's
I
the
mean, you thought you could beat it the first time, not you personally, of course. but
Look, there's
somebody thought they could beat it first. So the deal is, I get to interrupt you, you don't get to interrupt me. When you become the judge, it'll be different rules.
I'm just
But for
wanted to
this,
talk to you.
for today, humor me. So it looks like, you showed up the first time, oh, we can beat this, we can move it to federal court, and it turns out you couldn't move it to federal court. And so you come back, okay, well, now we'll say we're not subject to jurisdiction. That looks like you're just picking and choosing.
So Rule 120A says action. That's the rule that defines what we're doing here. Could I do something that creates an irrevocable consent to jurisdiction forever based on what I file in the first lawsuit? Possibly. There's a body of law about that, about waiver and consent. No one's arguing we did that. To the extent the due order of pleading rule is what we're talking about, it's cabined by an action. To avoid, I think, exactly this question, because if you pose that question, and that becomes the rule of decision, something in addition to just the word action, then all of a sudden, there's all these interactions between cases that can become the subject of discussion that have
And
not
you're-
been for years.
For action, you're relying on, I'm not finding the word action in 120A.
Proceeding, I'm sorry. It's proceeding, and the Jaster case in the Supreme Court talks about the interaction between the word action and proceeding. So the rule says proceeding. It's a synonym with action under the Supreme Court's Jaster case. So that's
Are we,
why I've been using that.
are we cabin to 120A and estoppel? I mean, back to the Chief's question, I don't understand fully why, if it's the same party, same underlying claims, and a party seeks to have jurisdiction enforced in Texas, why wouldn't that be enough for a trial court judge to find at least enough evidence of consent to proceed in that form?
Well, there's law out there about consent, and that hasn't been held to be enough. It's all been handled under this due order of pleading issue, which I think is dealt with. Also, too, remember what happened. We non-suited. And there's another body of law about that when that happens, everything is as if it never was. I mean, there's no issue preclusion effect from us filing the special appearance. There's no claim preclusion, or the motion to transfer. There's no claim preclusion effect. It just goes poof. And so if it goes poof for those purposes of what a final judgment can do, it doesn't seem like it would be the basis for some sort of
Well,
irrevocable
that-
consent to
again,
jurisdiction.
That's one of those rules that, in context, that's exactly what it means. But if if you had an person who was not an attorney who filed it, the claim, and then the unauthorized practice committee goes after them, and you non-suit it, it's not as if it never happened in that case. So it depends on the facts, the context.
True point. But it's a reference point here, right? We're trying to figure out what was the effect of those pleadings. That was something material that happened, and it does bear with it probably way more case law about what the effect of a non-suit is than any of these other issues about this guy filed suit here and this guy filed suit there. That's as good a starting place as any. And by the way, that's the end of the other estoppel argument they make, collateral estoppel. It says you can't non-suit something and get out of the effect of a final judgment, but of course there was no final judgment in the first action. It just went away. So collateral estoppel, claim preclusion has nothing to add to this except that the absence of it is a telling addition to the question of whether a waiver occurred. With that, I'll give the court my 17 seconds as apology for having interrupted.
Thank you, Mr. Cole. Mr. Caforio, is it?
Yes, Mr. Chief Justice. May it please the court, I'd like to touch on a few things here. This case is properly proceeding in Texas court against these entities under either waiver or estoppel, or actually minimum contacts, which the court below didn't reach with regards to these entities because it found they had submitted to jurisdiction. So first, with regards to the idea that a forum selection clause does not actually confer jurisdiction in this court, the Texas Supreme Court has said the exact opposite. The case on point, there are many, but Michiana, 168 Southwest 3rd at 792.
That's a great case.
Yeah, correct. Well-written, well-analyzed, a very nice opinion. And it said in a well-structured sentence, a forum selection clause operates as consent to jurisdiction in that forum. And so what we had right here, and I do want to be clear in the record here, and maybe they can point something out, but there was no special appearance filed in that first proceeding. There was a motion to dismiss, and there was an answer. And they sought specific relief, affirmative relief from that court, which they got. And you can look at the motion that they filed, and it is, now there are two clerk's records because we have two appeals, so I'm going to cite everything to the same clerk's record, which is for the second appeal. But on page 3074, CR 3074.
Let me get that straight. The first action and is it the third action, the clerk's record is identical?
No, so I'm saying the two appeals we have today, they're actually different CRs. The pages are
Do we have the first action record anywhere?
I don't know that it was broken up in that respect. We have all the filings from that action.
Somewhere in our record.
Yeah, and that's what I want to cite to right here, is in the CR that we have for the second case you're going to hear today, because I didn't want to bring in 10,000 pages. So in the CR that you have at page 3074 is the motion to dismiss that these entities filed in that first action. And they said, quote, the claims are within the scope of the foreign selection clause based on the plain meaning of the provision. They then said on the next page, those claims can only rely on the partnership agreement, thus enabling the affiliated Blackstone defendants to invoke the forum selection clause. The court then granted that motion and sent the court to the Northern District of Texas. Our argument was there's no subject matter jurisdiction in federal court. There's no diversity. There's no federal claim. Let's keep it here. They sought that affirmative relief, and the court said, yeah, the federal court needs to determine it doesn't have jurisdiction. We filed an identical claim. Sua sponte, that court said, there's no jurisdiction to hear this. You got to go back to the state court. So we filed the identical claim again, but we added one defendant, the individual. And once it came back, it was put to a different district, a different court. And so these parties moved to transfer it to the same one that the original proceeding was in. And they said in that filing that this is, quote, this is in the CR 3097, and they said on July 31st, 2023, plaintiffs filed the instant action alleging the same claims against the same parties arising out of the same transaction as the first action that the 298th District Court previously dismissed. That is, plaintiffs have once again asserted contract and fiduciary duty claims against the Blackstone defendants, PEC and Mr. Doyle, while also adding one additional defendant, Angelo Acancia, arising out of the sale of Primexx Resource Development, AAC. Indeed, many of the allegations in the instant action are word for word verbatim of the allegations in the first action. And then, after that case sat there for many months with nothing happening, the parties agreed that we would take it over to the business court and see if we could move things a little quicker. And here is a filing from defendants that the language here is pretty intriguing. This is in the record at page 3107, and it is a notice of related case. And page 3107, they say, the above referenced case was filed on July 31st, 2023 at 5:15 p.m. in the 68th Judicial District Court, making it the third filed case of this litigation.
Well, I guess, what does this mean though for the future? So, I mean, typically when we're looking at a special appearance, we're not like going and looking at what's happened in other cases. Does this mean that from, this point forward, when multiple lawsuits are filed, we're always going to be having to check and see what some other court is doing or what's going on when we've got a special appearance in front of us?
No, because you have the business court, the trial court, who looking at the facts said, this is identical, this is the same. They put in their own notice, this is the same litigation. And the three cases that my esteemed colleague pointed to all lead to the same outcome. Their best case is the Ford case. They rely on that a whole lot in their briefing. And the real key difference in that case was that Ford, in the initial litigation, never consented to anything happening in Texas. They said this case can only proceed in Mexico. It can't proceed in Texas. So it got sent to Mexico. 7 years later, they came back, and then they filed a special appearance, and the court found you didn't appear generally, you never said Texas was the right state.
Let me ask to switch gears on you for the, I'm also offended that neither one of you addressed Cornerstone Healthcare versus Nautic Management. I wasn't a judge on that one, I was just an attorney. It's 493 Southwest 3rd 65. And the Texas Supreme Court says, so this has a lot of analogies to your situation. This is what funds do, investment funds. The money's all up here, we find something to do, so we create a general manager of a general partner, of a limited partnership, of a local, and then we have the, there's a term for it, the companies, the,
A single purpose
or,
entity?
the actual investments, and they're the ones that have all the assets.
Yeah.
And so the question was, can you get these people who were in Rhode Island in that case? Now, a little different case because it was they targeted an investment, a corporate opportunity in Texas, and they took it, and they set up all this thing to do it. And the Texas Supreme Court says, no, you can sue them all in Texas because nobody else made the decision to acquire these hospitals other than the funds because nobody else had the money. I mean, that's who made the decision. If your people up here, the Blackstone people, and I assume those are the ones that have the money, and they made the decision to, now this may be a little different. They didn't make the, this wasn't the setup, this was the end. It was the other end of it was the burial process rather than the birth process. And so, but that's who is driving this ultimately, and obviously, I mean, that was the argument in that case was, yeah, but we have all these different companies and you can't just tie them all together, and that's normally true. But if you just created them, if that's the ones with the money, then that's the ones who targeted Texas with its decision to sell or whatever. So I don't expect you to know that just off the cuff, but I would appreciate your comments on that because it does look like if you all were the ones with the money and you all were the ones who gave the money and you all ones who got all the money, the funds did. That's what the funds do. Why is that not a minimum contact with Texas.
Well, and we certainly submit that it is, and that really comes up in the second appeal we're hearing today with regards to Blackstone Inc. and Mr. Acancia, who they aren't subject to this waiver finding because they were not defendants in the first action, so they didn't actually waive. But I think that's exactly correct. When you look at the factors of what it means to purposefully avail yourself to doing business in the state of Texas, to taking advantage of the state of Texas, from the top, and then every entity created on the way down, and there's a, we put the chart of each entity, it's the managing partner of the managing partner of the sole member of the, it goes all the way down, we have that in there, and they decided to put a few $100 million into a Texas corporation that owned real assets of Texas oil and gas. There were no employees up the chain. This comes in through Mr. Acancia. It was all controlled by Blackstone, by him. He oversaw the process. He made the decisions. He oversaw the board while they were, conducting business. One of the arguments they make with regards to Mr. Acancia is, well, there's no evidence that he actually made any decisions that were happening in a Texas board meeting. And if you look at CR 524 through 526, it's the minutes of the board meeting where they approved the sale in Texas of Texas oil and gas assets to another Texas company that Mr. Acancia attended and voted to approve that sale.
Which raises another question, since that isn't addressed in our briefs, because the business court did not rule based on that basis. If we find against you on the waiver or previous litigation in Texas, do we need to remand or address those points?
Yes, so I think technically you would probably need to remand. We were not allowed to take jurisdictional discovery with regards to these entities. We did take limited jurisdictional discovery with regards to Mr. Acancia and Blackstone Inc. after these entities were already found to be in the case through their waiver. But if the court didn't find waiver or estoppel, and if it didn't find that the record already had enough in it based on the arguments that were presented in the business court in the first instance, that chain up the command exactly as set forth by the Chief Justice, then we should be able to take jurisdictional discovery to establish those facts.
And remind me, this case, part of this case is still pending in the business court?
So it was a partial grant of summary judgment. There were some claims remaining. The parties agreed because what was granted was such a key component of the case that we would voluntarily dismiss those remaining claims without prejudice to refile with regard, once we got a ruling from the business court regarding the other claims. With regards to the estoppel component, so first we think it fairly directly fits into waiver. 120A talks about a whole proceeding, and every time it uses language, it talks about whether or not the party is amenable to service of process by the courts in this state. It's not so limited with regards to it has to be a particular cause number. We know that's not the case because of Massachusetts Bay. It's whether you are amenable to service of process by the courts in this state. And when they generally appeared, filed an answer, moved to dismiss, said the forum selection clause applies and we get to enforce it, and they won and moved it to a different federal court that then just kicked it right back because that court was unable to hear the case, they both generally appeared, and it would be a wildly inequitable result to let them pick and choose, take advantage of the Texas courts, and then because we were correct the entire time filing it in Texas state court because we knew that was the only place it could be litigated, we're now punished from moving forward in that proceeding that they had already generally appeared.
What do we do with the argument, though, that a non-suit means everything goes poof, that it's as if nothing ever happened? It's like when you get a bug in your computer and you have to do a hard reset and all your files are gone.
And that's just not what happened here. They filed a motion to dismiss and they answered in the case. And so they took those positions. They affirmatively represented to the court, we may invoke the forum selection clause. It applies to these claims. There's no magic eraser that you get to take away the affirmative representations you brought in a motion that you succeeded on, that you got a court in Texas to spend its time reviewing and issuing an order. They have no, there is no case they have pointed to that says you get to magically erase those representations and that affirmative litigation that they voluntarily chose to pursue. They could have filed a special appearance in that first action. And then we wouldn't be talking about waiver. Then we'd only be talking about how it went all the way up the chain and they purposefully availed themselves of the state of Texas.
So one other question I've been wanting to ask somebody about personal jurisdiction. Needless to say, personal jurisdiction's changed a lot with Southwest Airlines and everything else. So Worldwide Volkswagen says there's 2 reasons to have minimum contact test: the burdens of litigating in a distant forum. Now, are you litigating in a distant forum?
Our clients, no.
Right. Because they're located in,
Well, the funds themselves, and it's made up of a bunch of investors.
there's Delaware or
Yeah.
New Jersey, right?
Right.
And so you are litigating different, but practically speaking, that for clients like you and cases like we have in this court, that's not a burden anymore. The other one is principles of federalism. And again, you know, we have a global economy, if not at least a national economy. And, you know, if you're going to buy a big part, a big share of the Permian Basin, it doesn't sound that much of a federalism problem to say, well, come on down here and we'll work through that. So which of those factors, burden or federalism, says, or is it just the technical rules, we don't have to do it here? Sorry.
And all of that counsels to finding personal jurisdiction and purposeful availment in Texas. You have this company who decided to put $500 million into buying Texas oil and gas and running that company with its employees from New York. It's pretty, if not laughable, close to it for them to come in and say it would be a burden for us to appear in court, but it's not a burden for us to own all this gas, profit from this gas, and ship it back to New York. No further questions? Thank you, Your Honors.
Thank you. Mr. Cole? Again, same last question. What is the basis for why we shouldn't either? Is it burden, is it federalism, or is it something new?
Oh, I mean, there's no general jurisdiction because the headquarters isn't here, and there's no specific jurisdiction because the requirement that's been around for decades, requirements have not been satisfied. And we can say interests of federalism and sort of look at that from different perspectives, but yeah, interests of federalism. I mean, Texas courts are, do they have, we all think Texas has the power to run the rest of the country, but perhaps other states might have a different view of that. Perhaps we might have a different view if Idaho showed up here to tell us what to do. And that's not an idle formalism. It's a serious question of power, and those rules have been in place for decades. So I get it. When we're not arguing hardship, I mean, there's an override to jurisdiction if those requirements can be met, but it's unfair for some reason,
right.
Those due process factors, but that's not what this case is about. The question of disposition, ordinarily you would remand. I think because the jurisdictional issues here overlap considerably with the ones that were addressed on the merits, the court would be within its rights to examine those and affirm.
Do it all in
because
one big
there's not a lot of additional, measuring of things that needs to occur. That's already occurred on similar issues, and the court needs to go no further there. What I heard was missing in the sort of dramatic reading from various pleadings that my very well-spoken colleague did just now is an explanation of why there's an inconsistency for purposes of judicial estoppel. The question isn't just, is there some pleading somewhere where the word same appears? There are 2 precise questions posed here. There's the question of whether it's in the same proceeding, I said the right word that time. And there's the question of whether judicial estoppel, which applies everywhere, not just in personal jurisdiction, whether that representation of fact has something that inconsistent has been made. And remember, it's in a context where, as you point out, Justice Ferris, there was a non-suit. So there's no collateral estoppel effect, no issue preclusion, no claim preclusion. It's that wispy of a statement legally. For that to become the basis of judicial estoppel is a stretch. For this context and for judicial estoppel generally. And the argument that the rules refer in places to amenable to service by the courts of this state is clearly just a general reference to personal jurisdiction with kind of some fancy words in it, but it's not a suggestion that the word proceeding at the beginning of the rule means something other than what the well-established principle of that rule is. On the question about the company spending money in Texas, that kind of high-level summary. Let's not forget that Texas has a requirement, all courts do, but Texas makes it express in its personal jurisdiction test for specific jurisdiction about the operative facts of the case. The operative facts of this case involve a specific sales decision, and that's where this argument breaks down, because the contexts they point to either don't involve those operative facts, or they involve people who have not been shown to be acting as agents or whatever the other legal doctrine may be with respect to the relevant parties they've named. The alter ego claims here are not serious claims. These are independent entities for independent purposes that they know full well existed when they got into this deal, because there's nothing unusual about that structure. And the doctrinal requirements of specific jurisdiction and a connection to operative facts have not been satisfied here. And with that, I think I'll give my remaining minute back to the court.
Thank you, counsel. Court will stand in recess, brief 10-minute recess, and we'll take the other half.
All rise.